start
Good evening.
today's Golden Charcha. Request to Baid ji to special address for today's seminar.
Good evening, everyone. Very warm welcome to all of you. Today we are talking about succession planning, a subject that for most people comes with hesitation, discomfort, and very often delay. हम लोग उतना ध्यान नहीं देते हैं उस पे जितना हो सकता है डिले करते रहते हैं. But if the last decade has taught us anything, it is that life changes fast, especially the COVID period. बहुत uncertainties लोगों के लाइफ में आई उस टाइम. Businesses evolve rapidly, family structures are transforming, and wealth itself has started to span across geographies. In such an environment, clarity is no longer a luxury, it is necessity. If we look around us, we realize that in India, succession planning is still very much around family-driven economy. Most of our enterprises, अगर हम business enterprises को देखें, around 75 to 80% of those businesses are family-owned businesses rather than corporate structured or professionally run businesses. Yet, ironically, the question of what happens next is rarely discussed openly. Many assume succession planning is only for the HNIs or only for the elderly people, or that it's something that can wait indefinitely. But in reality, succession planning is not about age, it's about clarity. It's about ensuring that the values, the capital, and the legacy we built during our lifetimes are carried forward in the manner we intend. The good thing is that succession planning, when done timely and thoughtfully, does the exact opposite. It brings peace of mind for parents, confidence for the next generation, and protection for our businesses. And above all, continuity. It turns uncertainty into a direction. In today's session, we are going to touch upon two important tools that forms part of the larger succession framework, wills and trusts. While a will helps to ensure that our wishes are respected after our lifetime, a trust offers a structure during our lifetime that can protect assets, ensure continuity, and reduce complexity for the next generation. Both have their place and both are misunderstood in equal measure. Which tool suits whom and why is something that requires guidance. And we are very fortunate to have that guidance today. With that, it gives me a great pleasure to welcome our speaker for the session, CA Rajkumar Lakhotia sir. We are fortunate to have someone who understands not just the law and the documentation, but also the human and emotional realities behind succession. I am personally looking forward to the insight that will follow, and I'm sure all of us will find tremendous value in today's discussion. Thank you once again for joining in, and without taking more time, I now request CA Rajkumar Lakhotia sir to take over and lead us through this very meaningful topic. Over to you, sir.
2 सेकंड लूंगा भैया, 2 सेकंड लूंगा बीच में इंटरप्ट के लिए. ये राजकुमार लाखोटिया इज ए प्रैक्टिसिंग चार्टर्ड अकाउंटेंट. उनका प्रोफाइल तो आपने नहीं पढ़ा ना?
नहीं सर.
C. Rajkumar Lakhotia is a practicing chartered accountant with over 23 years of experience in taxation, including international taxation, auditing, business advisory, and estate and succession planning. He has worked across diversified industries, enhancing his understanding of the Indian and global economic landscape. He holds certification from ICAI in internal taxation, indirect taxation, and forensic audit and fraud detection. He also certified by BSc, BCCD, and NSC, NSFM, mutual and module, and regularly speaker at professional forum. Raj is a founder of dilsewill.com, India's leading online will making and succession planning platform, indicated by NASSCOM and recognized among the top 5 super startup by the government of West Bengal. He is also a regular contributor to ET Wealth on wills and succession issue. An architect, yogi, and Prenik Heller, Raj is actively involved with several professional associations and bring a visionary and purpose-driven approach to all his initiatives. So I request Raj Lakhotia ji to take today's session. Over to Lakhotia ji.
Thank you so much, Chimpu ji and Yash, for a warm introduction and rightly capturing the essence of succession planning. Yash, you have covered in your brief introduction. Good to know that people are realizing that succession planning is important, and yet people defer or delay in taking the steps. Now, we are in short of time. I'll just share my presentation and then we'll discuss about this. Can you just confirm? Can you see my screen?
Yes, sir.
Yes.
Visible.
Is my screen visible? Okay.
Yes,
Yes.
Perfect. So, when we talk about succession planning, this is one topic I strongly feel is a topic which is highly ignored so far as so far as Indians are concerned. We have been taught during our academic curriculum and in our even in our CA curriculum about how to earn money, how to manage the business, and once we earn money, how to invest that money so that we can create good amount of wealth. But how to pass it on to the next generation in a manner which is smooth and which is useful to the next generation is something which never been taught to anyone. Even in CA curriculum, there is not a single topic of discussion on estate and succession planning. Whereas, if I'll share the data with all of you, 76% cases in India are relating to property and family disputes. इतना बड़ा मैटर है और इसके लिए हम फिर भी आज की डेट में अपने घर में बात नहीं करना चाहते हैं, हम सोचते नहीं है क्या करें. But let me quickly go to the presentation. It's a topic which basically need understanding of law and situation. तो मैंने क्या किया कि एक स्टोरी लाइन बनाई है so that if we'll go with the story line, it will be easy for us to understand. So in my storyline, there is this guy called Ankur who is 55 years old, a self-made reputed businessman from Kolkata having interest in IT and IT-enabled services. I'm sure most of you will be able to correlate either your story or your family's someone's story or your friend someone's story with this storyline, which I have tried to create it. तो जनरली होता है क्या 25 साल के होने के बाद हम अपने बिजनेस में आने की कोशिश करते हैं. ये started Ankur has started his business when he was 25 from scratch, and today at a 55 years of his age he has built a very reputed business around IT enabled services. The products are well accepted in market. He is doing phenomenally well so far as industry is concerned. The top line is good, profit is good. Ankur father, who is a retired person and is totally dependent on Ankur. Ankur's wife, though she is a well-educated lady, but she chose to become a homemaker instead of joining Ankur's business or to understand Ankur's finances. Ankur has a sister who is widow and is dependent on him for his all the requirement for her all requirements. Daughter one is married against her father's wish. Love marriage है. Daughter one ने love marriage करने की सोची और Ankur was not interested. And since then, there are differences between Ankur and daughter one. दोनों की एक दूसरे से बनती नहीं है, बातचीत नहीं है. Ankur's daughter two, she married to a businessman who is selected by Ankur himself. आफ्टर मैरिज जैसा कि हम देखते हैं कि वाइफ को बिजनेस में डायरेक्टर बना दिया गया और डायरेक्टर्स बनने के बाद में बिजनेस वर डूइंग फेयरली वेल. बट इन पास्ट कोविड के टाइम में देयर वर इश्यूज इन द बिजनेस एंड द बिजनेस इज इन इंसॉल्वेंसी टुडे. एंड डॉटर टू बीइंग डायरेक्टर इन द कंपनी, she has given her personal guarantee against the loan taken by the company. And the last relationship that I have chosen for my storyline is son, who has gone abroad for higher studies and he's not interested to return back to India to join father's business because he has his own venture. He has started something in the foreign territory, and he is not interested to return back to India. Now, इस स्टोरी लाइन में आई एम श्योर आप किसी न किसी आदमी को अपने आसपास के इर्द गिर्द के लोगों को इमेजिन कर पाएंगे और कुछ ना कुछ पोर्शन इस स्टोरी लाइन का उनको इम्पैक्ट करता होगा. आई हैव सेलेक्टेड फ्यू रिलेशनशिप एंड फ्यू सिचुएशंस. नाउ, past में COVID में Ankur was also infected by COVID, and he, after a long struggle for 15 days, he ultimately uh, departed, and the hospital runs which are running in lakhs and which are yet to be settled. Now, what is the after effect of this incidence of Ankur's death? The immediate some of the after effects are family shocked and shattered. The head of the family who used to earn and provide to the family is suddenly not available. तो शॉक एंड शटर्ड होना तो बनता है, पर सबसे पहला सवाल दिमाग में आता है कि हाउ वुड द फैमिली मैनेज देयर इमीडिएट नीड. हमारी रोजमर्रे के जो खर्चे हैं, our rent, our salary expenses, household related expenses, education expenses, who will meet those expenses? जब तक हमें पता चलेगा एसेट्स कहाँ हैं, क्या है, कैसे उसको अपने कंट्रोल में लेना है और कैसे उनको लिक्विडेट करना है, तब तक के खर्चे कैसे मैनेज होंगे? Who will manage the business? As I said, Ankur's son is settled abroad. Daughter 1 से अंकुर की बनती नहीं थी. Daughter 2 ऑलरेडी एक कंपनी में डायरेक्टर है जो कि इंसॉल्वेंसी में है, और वाइफ ने कभी बिजनेस में इंटरेस्ट नहीं लिया. ऐसे सिचुएशन में अंकुर ने जो ये 30 साल की मेहनत से बिजनेस खड़ा किया, अपने स्वेट एंड ब्लड को देकर के ये बिजनेस खड़ा किया, जो कि आज की डेट में बहुत अच्छी पोजीशन रखती है, अच्छा मार्केट कैप्चर करती है, बट इन हिज एब्सेंस हु इज गोइंग टू रन द बिजनेस, और इस बिजनेस का क्या होगा? एंड लेट मी टेल यू, इंडिया इज अ एसएमई ड्रिवन इकोनॉमी. मोस्ट ऑफ द एसएमई बिजनेसेस आर फाउंडर ड्रिवन, एंड बिकॉज ऑफ such incidences those businesses are shut. रीजन बीइंग, कोई उसको देखने वाला नहीं है, कभी उसने कभी किसी के साथ किसी को हैंड होल्डिंग नहीं की, और बिजनेस की कंटिन्यूटी इज इन ट्रबल. तो who will manage the business? Who will take care of father and sister? Now, why father and why sister I'll cover later during my presentation, but for the time being, अभी father और sister जो कि totally dependent है अंकुर के ऊपर में, उनके regular maintenance का क्या होगा? Who knows what are the assets and liabilities he had and how to access that? अंकुर के फाइनेंसेस में कभी किसी ने इंटरेस्ट नहीं लिया, किसी को पता नहीं कि उनके एसेट्स क्या क्या है और लाइबिलिटीज क्या है, एंड कैसे उनको हम एक्सेस करें. हाउ वुड वन प्रोटेक्ट फ्रॉम मिसअप्रोप्रिएटिंग वेल्थ एक्यूमुलेटेड फॉर द बेनिफिट ऑफ फैमिली? नाउ, सिंस नोबडी नोज व्हाट आर द एसेट्स दे हैव, and that is where the outsiders start influencing the family members, and there are chances of misappropriation of wealth. And how how would one protect from that misappropriation to be happen, and how to protect second daughter's share from getting it attached by the court? Ab daughter 2 being daughter of Ankur, she has inherent right into the wealth of the deceased. Now, if she gets anything out of the state of Ankur, then definitely the bank will attach those properties and assets and will satisfy their loan. Now, अंकुर ने कमाया, ये सोच के कमाया है कि परिवार की जरूरत के समय में उनको काम आएगा. ऐसे समय में जब पैसा परिवार के लिए होना चाहिए था, इसको बैंक ले जाती है. कैन यू हेल्प द फैमिली टू प्रोटेक्ट दैट मनी? यस, यू कैन, बट फॉर दैट यू हैव टू टाइमली टेक द स्टेप्स. Also, how to protect the distribution of wealth to first daughter. As I said, Ankur was not having cordial relationship with first daughter. He was not interested to give a single paise out of his wealth to daughter 1. But in absence of any instrument in place, in absence of succession planning in place, nobody can stop daughter 1 from inheriting the wealth which he is legally entitled to out of Ankur's wealth. These are some of the after effects. If we keep discussing, we'll get a lot many such. As I said, 76% cases are relating to the property and family disputes. Around 3 crore cases pending है India में in various courts. 76%, that comes to around 2.3 crore cases which are belonging to property and family disputes. Such a big magnitude of problem which we are going to discuss about. यदि हम दुनिया की बात करें, इंडिया being a progressive nation always try to follow US, UK being a developed countries. US may people are aware of the succession rights. Government also try to create awareness so that people make will or trust or any form of succession tools so that the succession is smooth to the next generation, irrespective of their age, irrespective of their income, irrespective of their education. People have some or other tools in place. Similarly, for UK, uh, the same thing. However, if we talk about China, which is also world's most populous nation, I mean the number one populous nation in the world, second largest economy, and China is also facing the similar problem of succession deficiency, because of which lot many cases are traveling to the courts. With this background, let's try and understand. So, what is a succession planning? Is succession planning is a process through which you ensure transfer of wealth, assets, properties, business, or whatever you own to the next generation in a hassle-free manner, and in the manner in which you want them to, pass on to the next generation. So there are many type of tools which are used for the succession planning. There are, broadly speaking, there are two aspects of succession planning. One is personal succession, the other one is business succession. We will discuss more about personal succession today, and I'll try to touch upon a part of business succession as well. But then, in order to ensure the passing of wealth of person per se, as well as passing of business to the next generation, we need to ensure certain tools to be in place, and these tools are cumulatively tools which are used for the purpose of succession planning. Now, for the personal succession, the most widely used tool is will. A will is a document which is considered as a legal declaration of the intention of testator. It is about intention of the person who is writing the will, and about the distribution or disposal or of his possessions, assets or properties after his death. As I said, it the will document reflects what was the intention of the testator and how he wanted to distribute the assets after his death. So there is no fixed format of will. आप किसी भी तरीके से अपनी will बना सकते हैं. In fact, if I have to tell you, the shortest will till date is three-word will, which is all to son. That's it. However, with passes of time and with so many cases which are traveling to the courts, there are certain precautions which we suggest one should take while drafting a will document, and that is why it is always advisable to take help from the competent person. Otherwise, यदि आप गूगल में जाके सर्च करेंगे तो यू विल गेट एन नंबर ऑफ फॉर्मेट्स. आप किसी भी फॉर्मेट को निकालिए, अपना नाम भरिए और आपकी विल बन जाएगी. It can be a handwritten, it can be on plain paper. There is no need of stamp paper. And not just your tangible, but your intangible assets also you can bequeath through your will. Now, we are living in an era where a lot of our transactions are happening online. Most of our documentations are now kept in our Gmail or Google or some other servers. Instead of keeping physical documents, now people are keeping digital documents. Who are entitled to access these accounts, these documents, or any other intangible assets like crypto or any other assets which we have? So all those intangible assets also one can bequeath through the will document. Now there are it's a legal declaration which reflects the intention of the testator, and it is with regard to his own property. जो उसके नाम की प्रॉपर्टी है, जिसकी उसकी लीगल ओनरशिप है, उसी प्रॉपर्टी की आप विल बना सकते हैं. किसी और के नाम पे जनरली हमारे घर की फाइलों में हम अलग अलग प्रॉपर्टी क्रिएट कर लेते हैं, बट जिसके नाम की फाइल है या जिसके नाम पे प्रॉपर्टी है, वो विल उसी की बना सकते हैं. It manifests only after the death of the person. So till the time the person is alive, it's merely a paper document. It becomes a legal document only after the death of the person. Death के बाद में ही will motion में आती है, उसके पहले ये पेपर है. आप कभी भी फाड़ करके दूसरी will बना दीजिए. That is what it is suggested, that it can be revoked or reviewed any number of times during the lifetime of a person. There are four important parties to a will document. The first is testator or the testatrix who is writing the will. The second, which is very important, is beneficiary, who is typically a person who is going to derive any property, assets, right, title, or interest through the will document. A beneficiary can be an individual, or a non individual can also be a beneficiary. Now, here the importance of will is, at times we have this interest that we want to serve to the society. We want to part away some part of our wealth for the benefit of the society. We want to support some NGO. So in absence of will, it is not possible, because in absence of will, the law will take place, and law will not recognize anyone other than the family members as the legal heirs. सो यदि किसी का इंटरेस्ट ये है कि वो किसी संस्था को, किसी ऑर्गेनाइजेशन को, और किसी नॉन इंडिविजुअल को सपोर्ट करना चाहते हैं, बेनिफिशियरी बनाना चाहते हैं, तो ही हैज टू मेक द विल. लाइक हमने पास में रतन टाटा सर की विल देखी, जिसमें ही हैज earmarked some fund for his dog. That has become possible only because he has made the will. Similarly, a beneficiary can be a relative or can be a non-relative as well. Now, in absence of will, the law recognizes only few relatives who are defined in the law as the legal heirs. However, if you want to support anyone, say suppose there is some employee who is very loyal to you, or there is some friend who has been very helpful to you during your difficult times, or somebody else, then you can give assets to your non-relatives also through will. Otherwise, it is not possible. A beneficiary can be a minor or a person with special need as well. एंड सबसे अच्छी बात क्या है कि हम बेनिफिशियरी में एक नॉन बेनिफिशियरी भी बना सकते हैं. नॉन बेनिफिशियरी कौन होता है? जिसका कि अदरवाइज बाय वर्च्यू ऑफ लॉ इनहेरिट राइट है प्रॉपर्टी में. लाइक डॉटर वन, इन आवर केस अंकुर की डॉटर वन का इनहेरिट राइट है इन द वेल्थ ऑफ अंकुर. नाउ यदि अंकुर अपनी विल बनाते और उसमें रीजन देते कि वो डॉटर वन को क्यों नहीं देना चाहते हैं, क्या नहीं देना चाहते हैं, then that would definitely be given effect to. So that is the benefit of having will in place. Similarly, the third important party to a will document is an executor, who is basically interested with the task of putting the will in motion, going to the court, obtaining a probate, and distributing the assets as per the provisions which are given in the will document. Executor can be a single person or a multiple persons can be executor. It can be individual, non-individuals also. There are professionals and executors who are available in the market today. And the last important party to a will document is witness. In order to have a legally valid will, you have to have at least two witnesses in place who confirms that the will is signed in their presence, and those witnesses should be an independent person. Now, once after the death of the person, the will is submitted to the court with the probate application and probate petition, and then once the probate is granted, then the assets can be distributed to all the parties, all the beneficiaries as given in the will document. Now, if suppose there is no will, then for the movable assets, you need to obtain the succession certificate, which defines the details of the legal heirs, and then the assets gets distributed to all the legal heirs as per the law. Now, any person who can make the will, any person who is major and who is of sound mind. There are two requirements. Major होना चाहिए, sound mind होना चाहिए. So a person who is terminally ill, old person, or a illiterate person can make the will. However, any intoxicated person is barred. One who doesn't understand what he is doing, or one who is not in his sound mind, cannot make his will. Similarly, a deaf, a dumb, and blind can also make the will, provided they understand what they are doing. और ordinarily insane person like गजनी मूवी के आमिर खान, सवाल ये आया कि गजनी मूवी के आमिर खान क्या वो अपनी विल बना सकते हैं क्या? तो the law suggests that a person who is ordinarily insane can also make his will during the period of his sanity. ये बात अलग है कि ये sanity में था कि नहीं था, ये आप कैसे प्रूव करेंगे? I'll give a hint for that as well. Now, what happens if there is no will in place? Then the succession law of land comes into the picture. And in India, the succession law is based on the religion of the person. If he is a Hindu, Jain, and a Sikh, then the Hindu Succession Act, which is applicable to him. In case of Christian, Jew, and Parsi, Indian Succession Act is applicable. And in case of Muslims, Muslim law is applicable to them. What happens when a male Hindu who dies without will? So, in case of a male Hindu who dies without will, there are four classes of legal heirs who have been defined: class 1, class 2, class 3 and class 4. सबसे पहले हम क्लास 1 में जाते हैं, जिसमें कि there are typically four relationships which are defined: मदर, विडो, सन एंड डॉटर. इन चार रिलेशन में जितने जन अलाइव हैं उनको प्रॉपर्टी इक्वली डिस्ट्रीब्यूट हो जाती है. एंड इफ सपोज सन एंड डॉटर प्री डिसीज्ड है, तो सन एंड डॉटर का शेयर उनके हस्बैंड, वाइफ या बच्चों को इक्वली डिस्ट्रीब्यूट हो जाता है. सो इन आवर केस, सिंस अंकुर्स मदर इज नॉट देयर, अंकुर्स वाइफ, two daughter and son, four of them, they all gets 25% each into the property of Ankur, into the wealth of Ankur. Now that is where that is why I put purposely father and sister also who are dependent on Ankur, because father and sister are not considered as class 1 legal heir. This is really it's an irony कि father को क्यों class 1 में नहीं रखा है. There are lot many representations which has been given to the parliament, but nothing has happened so far. Now, if the father is dependent and you have not made the will, or if the sister is dependent, you have not made the will, make sure that you are inviting trouble. Now, if there is no one in class 1, then we move to class 2, which typically covers, there are number of entries which are given in the class 2, and we go one after other. और जिस एंट्री में कोई भी रिलेटिव अवेलेबल होते हैं, उस एंट्री में जितने रिलेटिव्स हैं उनको इक्वली डिस्ट्रीब्यूशन हो जाता है. सो क्लास 2 टिपिकली कवर्स द सिबलिंग्स, फादर, कजन्स, ये सारे जितने भी रिलेशनशिप वाले जो आते हैं ये क्लास 2 में आते हैं. Now, if there is no one in class 2, then we move to class 3, which are called ignates, who are related through blood, through father in the family, through male members in the family. And if there is no one in class 3, then we move to class 4 legal heirs, which are called co-ignates, which are related through blood, through female members in the family. This is the order of succession in case of a male Hindu who dies without will. I'll skip this illustration in the paucity of time. Similarly, in case of a female Hindu who dies without will, there are order of succession which has been defined. First, we have to understand what is the absolute property of a female Hindu, which she can deal with in any manner she wishes to. A female Hindu's property is consists of property which she has acquired by way of inheritance or by way of partition. I'm sure all of you are aware that if out of the partition of HUF, daughter being considered as co-partner post 2005 amendment, daughters are now considered as co-partner and they get some share in the partition of the HUF. That becomes her absolute property. Any assets or property which she has acquired in lieu of maintenance, maybe because of divorce decree or otherwise, she has got any property assets, it has become her absolute property. Any property which she has acquired by way of gift, or she has purchased out of her own money or her own skill, these are considered as her absolute property. And in her case, the order of succession is, firstly, it is distributed to son, daughter and husband equally. तो यदि फीमेल लेडी के सन, डॉटर, हस्बैंड में कोई भी है या सारे हैं, तो उन सबको इक्वल डिस्ट्रीब्यूशन होता है. बट इफ सपोज सन, डॉटर एंड हस्बैंड आर नॉट देयर, द लेडीज अलोन, देन इन दैट केस द entire amount goes to the legal heir of husband. Now imagine a situation where the lady is the only daughter of her parents, and her parents are dependent on the daughter. Now, in absence of will, the daughter's wealth would not go to her parents. It will go to either to the son, daughter, and husband, or it will go to the legal heir of husband, which is class 1, class 2, class 3 and class 4, जो कि इतनी लंबी लिस्ट है, कोई ना कोई तो वहां पे ले ही लेगा पैसा. And that is why it is also very important for a female to think of making a will. Now, if suppose none of the legal heir of husband is alive, which is very rarely a case, then the property would go to the parents of the lady Otherwise, it goes to the legal heir of father, and, or else it will go to the legal heir of mother. This is the order of succession in case of a female Hindu dies without will. However, there are two exceptions to this rule. If she has inherited any property from her father, and at the time of her death, she doesn't have any children. So, not father, parents. And at the time of her death, she doesn't have any children. Then that particular property, only that particular property which she has inherited from her parents, would revert back to the father's legal heir. Similarly, if she has inherited any property from husband or father-in-law, then at the time of her death, she doesn't have any children. Then that particular property would revert back to the husband's legal heirs. This example, again, I'm skipping. So similarly, in case of Christians, the property firstly distributed if the leftover relatives are widow and lineal descendants, then one third goes to the widow and two third goes to the lineal descendant. If the leftover are widow and kindred, then one half goes to the widow and half goes to the kindred. If uh, only widow is alive, then everything goes to the widow. In case of Parsis, similarly, widow and children all gets equal share. Only children all gets equal share. Widow, children, and parents. Widow and children gets equal share, and parents get half of the shares of each child. In case of Muslims, the law is different. You need to derive the share of each and every person, taking X as hypothesis. The son gets double of what daughter gets. Daughter gets half of what son gets. Spouse gets spouse, if spouse is wife, then she gets 1/8 share if they have children, and otherwise she gets 1/4 share. If the spouse is husband gets 1/4 share if they have children, otherwise gets half of the property of the wife, and parents gets 1/6 of the property. So the equation has to derive in order to understand who is going to inherit what. And that is where the entire importance of will is. As we have seen that when the law comes into the picture, there are fixed rates or fixed percentage which has been defined and fixed relatives who are defined. And that is where, जैसा हम बचपन से सुनते आए हैं, पांचों उंगलियां बराबर नहीं होती, तो सारे फैमिली मेंबर्स की रिक्वायरमेंट भी बराबर नहीं होती है. And being the head of the family, it is our duty to take care of the need of each and every family members in the manner they require. Now, in absence of will, किसी को ज्यादा मिल सकता है और किसी की रिक्वायरमेंट कंप्लीट नहीं हो सकती है, एंड ऐसे सिचुएशन में डिस्प्यूट्स अराइज होते हैं. ऑल्सो इट इज ऑल्सो द इंटेंशन ऑफ द डिसीज कि वो अपनी फैमिली को के नीड्स को टेक केयर करना चाहता है, बट बिकॉज ऑफ एब्सेंस ऑफ द विल डॉक्यूमेंट, द प्रॉपर्टी गेट्स डिस्ट्रीब्यूटेड इक्वली टू ऑल द मेंबर्स, इररेस्पेक्टिव ऑफ वेदर उन्हें नीड है कि नहीं है. To support your near and dear one as per their need. As I said, you may have some employees who are very loyal to you, some relatives like in our case, in case of Ankur, father and sister, जो कि relative है, near and dear है, लेकिन they are not class one. And Ankur wanted to support them, but in absence of will, it is not possible. Also, in order to fulfill your philanthropic or the financial goals, and to help the family to maintain the life, even if you are not available. Possible issues, there are irreconcilable disputes in the family. Testator की खुद की wish पूरी नहीं होती है, maintenance of family may be affected, and the study suggests कि यदि कोई भी matter court तक जाता है, तो in general it takes 10 to 15 years to settle the disputes. Now imagine the situation, आपकी hard earned money for the benefit of the family, and at the time when the family needed it most, it is lying with the court, and only person who is getting benefit out of it is the lawyers. So that is where it is highly important for all of us to understand कि एक सिंपल स्टेप जो कि आपकी लाइफ की पूरी साइकिल को कंप्लीट कर सकता है, उसे नहीं लेने से कितने तरह के इश्यूज आ सकते हैं. And also, in absence of succession planning in place, process of transfer of assets become very lengthy and cumbersome. There are many myths relating to the subject. Will need to be registered or will need to be on stamp paper. There is absolutely no need as such. Unregistered will is equally important than the registered will, and there is no need of any stamp paper also, because Stamp Act has not asked for any stamp on the will document. So if you are writing a will on a plain paper, it is equally good. आई हैव अपॉइंटेड नॉमिनी, डू आई नीड विल? ऐसा हर बार हमेशा ये क्वेश्चन हर फोरम पे आता है कि नॉमिनी तो अपॉइंट कर दिया, फिर क्या जरूरत है? लेट मी टेल यू, नॉमिनी इज नथिंग बट अ केयरटेकर, a trustee who is interested with the task of holding the assets till the time the legal heirs are established by the law. Till the time it is not established, he can hold the assets. Once the legal heirs are determined by the law, the nominee is duty bound to equally distribute the assets to the legal heirs. So nomination, ये अलग बात है कि the person to whom you want to give anything, you can make him also a nominee so that it is ease of transfer. But then solely nominee doesn't serve your purpose. I have joint holders. Do I need will? Yes. In case of joint holding, there are two type of situation. कभी कभी हम joint holding just for the sake of ease of operation करते हैं. In that case, the property belongs to one person and he needs to part it off through will in the manner he wants to. Second situation could be that both the parties have contributed in the manner they want to contribute. In such situation, you are the owner of your share of the property and you can distribute that through the will. इट्स टू अर्ली टू मेक द विल, ऐसा भी लोग बहुत पूछते हैं कि इतनी जल्दी क्या पड़ी है, अभी तो हम जवान है, अभी हम वी आर young, why do we need to make the will? My father should think of it. Let me tell you, and we have seen lot many cases of young deaths, especially after the COVID. The expiry date is not mentioned in on anybody's body. In of late we have seen in last 10-15 years the concept of individual family has increased a lot, and that is where the importance of having will in place has also increased. Earlier joint family होती थी, किसी की फैमिली के को यदि कुछ तकलीफ आ गई तो बाकी के फैमिली मेंबर्स मिलकर के उस फैमिली को हेल्प करते थे सस्टेन करने में। पर आज की डेट में हर एक फैमिली अपनी अलग अलग फाइनेंसेस लेके चलती है, एंड दैट इज वेयर इट इज वेरी इंपॉर्टेंट as soon as and we suggest that as soon as one start earning and have dependents, one should consider making his will. What if I change my mind? As I said, you can revisit your will n number of times. There are, if there are small changes, you can make codicil. If there are major changes, you can rewrite your will, destroy your earlier will, and you can mention that this will shall supersede all your existing will. So there is no limitation so far as how many wills you can make, how many times will you can make your will. Why will I can gift? ऐसा भी बहुत जन पूछते हैं कि हम गिफ्ट दे दें, वाई टू गेट इनटू द अननेसेसरी डिस्प्यूट ऑफ गेट मेकिंग द विल, फिर फ्यूचर में कोई लड़ाई का इशू आए. लेट मी टेल यू, वंस यू गिव द गिफ्ट यू immediately relinquish your right in the property, and gifts are irrevocable in nature. So after giving the gift, the person will behave or not behave in the manner you would like him to behave. There is no guarantee, and in that case you cannot ask the person to give you return back the gift. And there are stamp duty which are applicable, and there are tax implications also if the person to whom you want to give the gift doesn't fall under the definitions of relative under 56 to 10 of the Income Tax Act. We have classical example of Singhania versus Singhania, जिसमें Mr. Vijayapad Singhania has given away as gift to his son Gautam Singhania 100%, 37% of his stakes in Nevant's company, and now he is struggling for his own survival. Cross-border inheritance is also recognized the will document FEMA के through आप under FEMA a resident can give foreign assets, securities, property to a person resident in India, and vice versa also. Can I bequeath my undisclosed assets also through will? There is no bar as such, but you have to be very careful, because once the AO get to understand that these are undisclosed assets of the deceased person, then they are within their right to recover the due taxes thereon out of the estate of the deceased person. So you have to be very careful if any such matter is with you. HUF assets, you have undivided share in the HUF. You can bequeath your undivided share in the HUF through will, and that is also possible. So these are some of the areas relating to the will. The second important, I'm running little fast because of the paucity of time. I'll just try to cover trust also in next 5-7 minutes, which I have. The second widely used tool for succession planning is trust, which is highly useful in the case where the beneficiaries are minor, beneficiaries are not dependent, beneficiaries are not of sound mind, or in cases where there are state duty implications, or where you want to give benefits to the beneficiary without giving the ownership of assets to the beneficiary. So trust is a very useful tool when you want to have complete control during your lifetime on the assets, as well as after the death of the person also you can have a better control. So there are multiple type of trust which one can think of. The first is discretionary trust, wherein the settlor transfer the assets to the trust and appoint trustees who has been given discretion to decide to when to give and how much to give to which of the beneficiaries. The beneficiaries are defined by the settlor, but then the time and the manner in which the assets of the trust property will be distributed to the beneficiaries are the discretion lies with the trustee. These are called discretionary trust, and these are taxed at the maximum marginal rate because the beneficiaries may or may not get anything. So the trust is taxed at this in this case. Similarly, the other type of trust is called determined trust, wherein the share of each and every beneficiaries are predetermined. So trustees are mainly a caretaker who are interested with the task of holding the property, maintaining it, and transferring it as per the trust charter which has been defined by the settlor. In such case, the trust is taxed at the rate at which each and every beneficiaries are taxed. The third type of trust is called revocable trust, where the settler reserves the right to revoke the trust property. And the fourth type of trust is called irrevocable trust, where the trust property cannot be revoked. Once given to the trust, it becomes a trust property, and the settler doesn't have effective control on the ownership of the property, though he has the control on the way the property will be handled. It's a very widely used tools for the ring fencing. As in our case, यदि अंकुर ने एक ट्रस्ट बनाई होती, ट्रस्ट में डॉटर टू को बेनिफिशियरी बनाया होता जिसके की इंसॉल्वेंसी के मैटर चल रहे हैं, और अंकुर ने डॉटर टू के बेनिफिट के लिए उसमें प्रॉपर्टी रखी होती, तो डॉटर टू की ओनरशिप नहीं होती प्रॉपर्टी में, बट राइट टू एंजॉय होता. And in such situation, possibly the bank would not be able to forfeit the property to settle the loan. So these are the tools which helps a lot to the client, to the people, in order to manage their finances and ring fence their assets from the outside liabilities. Trust बनाए या will बनाए, it depends on multiple factors. The some of the factors are when would you like to give effect to the document. The will becomes effective though you make the will today, but it becomes effective only after the death of the person, whereas trust may be created today itself or may be created after the death. The second factor is probate dispute litigation. In case of will, you have to obtain probate. There are chances of dispute. Yes, there are chances of dispute. But in case of trust, there is no such scenario which can be possible. Control after the death through will. There is once the property is distributed to the beneficiaries, then the deceased do not have effective control on any of the assets. However, in case of trust, since the settlor defined the trust charter and the manner in which the property will be dealt into immediately, so he has effective control even after the death of the person. Possible during lifetime, will is not possible because will be effective only after the death of the person. However, trust one can create today itself. State duty savers, through will one cannot save the state duty, but through trust one can save the state duty. And when planning for minor beneficiaries through will, it is possible to a certain extent, but there are scope of manipulations. However, through trust, it is a very useful tool. Few tips if you want to avoid litigation: keep your will at safe place. Inform that you have made the will, but do not discuss the content of the will. Share the place of storage with the executor only. Sign will in presence of witness. It is very important that you should sign the will in presence of witness, and the witness should sign in presence of you. Attach doctor certificate about your physical and mental status because that will help a lot to understand whether the will has been made out of our own will or not. And also mention that this will supersedes all the existing will if you have made any during the past. And also nowadays people have started video recording the will signing ceremony to give an additional evidence to the court that the will has been made out of his own will and not under the force of the coercion. What should you mention in the will? Date on which you are writing the will, your personal details, declaration that you have sound mind and good health. Mention that this is your last will and you revoke all your existing will, whatever you have made during your past. Who is the executor? Who all are the beneficiaries? Assets. What assets goes to which beneficiary, and who all are the contingent beneficiaries? Now, contingent beneficiary is a person who gets the right if the primary beneficiary is not available or not ready to accept the bequest. A non-beneficiary also, like I discussed in our case, daughter one could be a non-beneficiary, so you can define a non-beneficiary. Special conditions, your last rituals, how to meet, what are other things which you want beneficiaries to do, and that the witness and the testator should sign the will document in presence of each other. So these are some of the aspects relating to the will or trust in the limited time which has been allotted. I could cover this much only. And if you have any question, I'm free, open to deal with all the questions that you have. Over to you, Yash. Thank you so much for this wonderful opportunity.
लाखोटिया जी, ये ओम प्रकाश अग्रवाल का कुछ क्वेरीज था।
हाँ, एक सेकेंड।
चैट बॉक्स में लिखा है उन्होंने।
हाँ, ओम प्रकाश जी ने ठीक लिखा है। So the requirement of probate was there for Chennai, Kolkata, and Mumbai compulsorily, but that has been recently been removed. So that's a welcome step. However, probate के benefit है कि once you get the probate, then all future disputes relating to any of the distribution get settled. What we suggest is that if there are multiple properties and in order to avoid any future, challenges, it's better to get it probated. Reason being, आप जब प्रॉपर्टी ट्रांसफर के लिए जाएंगे, एसेट्स ट्रांसफर के लिए जाएंगे, तो हो सकता है कहीं पे आपको बोले कि सारे के सारे बेनिफिशियरीज जो हैं या सारे के सारे लीगल हेयर्स हैं, उनको प्रेजेंट कीजिए, उनका एनओसी पेपर में देने से नहीं चलेगा. सो डिपेंडिंग ऑन केस टू केस, we suggest that probate still, though it is not mandatory now, you should obtain.
Is there any question from participation?
Marathon था. It was, this 45 minutes were too less on this subject. I tried to cover the entire side, so I was running like.
नहीं, अगर 5 मिनट अगर कुछ बोलना हो तो भैया 5 मिनट और अपने ले सकते हैं.
सर मेरा एक क्वेश्चन है.
हाँ,
बड़ा ही बेसिक क्वेश्चन था सर, बट जैसे विल में अपने देखते हैं कि एक जनरली सीक्रेसी भी बहुत लोग प्रेफर करते हैं कि मेंटेन करें कि तो उस टाइम वो विल जो रहती है वो किसके कस्टडी में रहती है, और देयर आर स्पेशलाइज्ड एजेंसीज जहां पे हम इसको, सो दैट आफ्टर द डेथ ऑफ द पर्सन वो कैसे विल ऑपरेशन में आती है? इज समवन गिवन दैट रिस्पॉन्सिबिलिटी?
राइट. So I'm coming to that. So you can keep will with you. You can keep will with your executor.
Okay.
And there are custodians who are providing the services of keeping your will document. Okay. Now, having said that, you have to inform your family members that I have made a will, and if anything happens to me, kindly search this document and kindly talk to these people. Some sort of clarity you have to give. ठीक है. विदाउट विच, जैसे ऑर्गन डोनेशन होता है ना, हमने ऑर्गन डोनेशन के लिए प्लेस तो कर दिया, अब किसी को पता ही नहीं है और उनको भी पता नहीं कि हम इनकी डेथ हो गई है, तो कैसे आए? तो सम सॉर्ट ऑफ क्लैरिटी यू हैव टू गिव टू योर फैमिली मेंबर्स सो दैट दे कैन सर्च फॉर इट. ठीक है. अब पास्ट में ऐसा भी हुआ है कि डेथ हो गई, एसेट्स डिस्ट्रीब्यूट हो गए, 10 साल बाद में पता चला विल डॉक्यूमेंट था कहीं पे पड़ा था, ठीक है, तो still that will document is valid, and then everything has to undo and then redo. So
Okay.
that's the
Okay.
scenario. Sarika Sabu has raised hand. Please unmute and ask the question. Do they can unmute themselves? Can they unmute themselves?
नो नो, करना पड़ेगा भैया, 1 मिनट। एडमिन
कर दीजिए ना unmute, उनको दे दीजिए पावर अप, तो किसी को क्वेरी करनी है तो।
EIRC से कोई सुन रहे हैं क्या?
हेलो,
ये अनम्यूट सारिका साबू को अनम्यूट कीजिए ना, साबू जी को। राज भैया, उनका क्वेश्चन है व्हाट इज बिजनेस सक्सेशन?
first is my first question is just a moment. My first question is what is business succession?
Okay, so what happens is there are many businesses which is run by the founders. Now the founder has attained the age of 60, 65. There is no one in second line who is going to take over the business. There are two aspects, ownership and the management. Okay. Now, what should you do? Either you create a second line, groom the person so that the business will be continued and the ownership can be established with the family so that the family keep getting the benefits of the business, or you invite some professionals who can handle the business, CEO, CFO type के आपने बना लिए, and then the ownership remains with the family. The business will continue and business will keep giving the dividend and the royalty to the family members. Or the third aspect is that you see that there is no one is going to come to this business in your family. Neither it is possible for you to create a professional structure around. Then you try and find out someone who can take over your business, give you value for the business which you have today based on whatever you have created. Have some sort of relationship that till the time you are alive you will be having some position in the business which has been taken over by this company, and after you are no more, then the business will belongs to the person who has taken over. So these are three types of possibilities that happens in the business successor. अब इसका फायदा क्या है? लाइक अंकुर के केस में, अंकुर ने जो 30 साल 35 साल अपने बिजनेस में दिए, बिजनेस अच्छा था, एम्प्लॉयज थे, प्रोडक्ट एक्सेप्टेबल था, प्रॉफिटेबिलिटी थी, सब चीज थी। द डे अंकुर इज नॉट अवेलेबल, तो सारे के सारे जीरो डाउन हो जाएंगे क्योंकि सारे कॉम्पिटिटर्स आपस में बांट लेंगे। बट यदि अंकुर ऐसा कोई इन तीनों में से कोई भी स्टेप्स ले लेता है, तो डिस्पाइट अंकुर रहे या नहीं रहे, the business will sustain, the market will keep getting the products, the family will keep getting the benefits or the corpus of the business, and the employees will continue. So this is what an important aspect which SMEs should look into. I hope I am able to understand your to reply to your query. Yes, please unmute yourself.
Hello, can you hear me?
Yes, I can.
yes.
Yeah, like in my case, the business is professional business. So there has to be another certified public accountant to run it. So while I am there, I'm running it. I don't want any other partner to join. So what happens the day I'm not there? Because my employees have been serving for years. I want them to receive the benefit also when I'm not there. So
This is what happens with all the CAs as well, Sarika ji. Most of the CAs are proprietorship, though it is in the nature of
I'm
partnership.
CPA.
Right. I know you are CPA, but I'm saying this is the same condition is all the CAs as well. So you need to structure it out in a manner that किसी ना किसी तरीके से ये बिजनेस जो आपने जो प्रैक्टिस स्टैब्लिश कर रखी है वो प्रैक्टिस यू हैव टू कंटिन्यू.
Yeah, at least my employees should
uh,
benefit going forward.
that has to be worked out. Yeah.
And one more
Hello.
question: who are the legal heirs in case of a spinster?
Your voice is not very clear.
Who is the legal heir in case of a spinster?
Hello.
Who are legal heirs? Can you hear me?
हालिका जी, मैं आपके बेहाफ में क्वेश्चन बता देता हूँ भैया को।
Ah.
राज भैया,
हेलो।
मेरी आवाज आ रही है?
हाँ
Who are
हाँ हाँ
legal
बोलिए।
heirs for a spinster?
सिस्टर।
Hello. Who are legal
Can
heirs
you
for a
type
spinster?
in the chat box? Can you type in the chat box, please? There is some
चैट
issue
बॉक्स
with
में
the...
लिखा है उन्होंने।
One second. Let me check. चैट बॉक्स में लिखा है ना?
हाँ, क्वेश्चन आंसर है ना, उसमें लिखा है।
क्वेश्चन आंसर वाला में।
हाँ,
What is business succession last है?
उसके बाद भी है।
Spinster as in unmarried woman, right?
Yeah.
Same,
Yes.
it is same. It is same. The order of succession which I have discussed, section 15 of Hindu Succession Act. First is husband, son, and daughter. In case of unmarried woman, the first line is not available, second line is not available, then the parents will become. If the parents are not there, then the legal heir of father. The legal heir of father would be your siblings. And if you do not have any siblings, then it goes to the legal heir of mother. That is your again your siblings, or if siblings are not there. So legal heir of father will have, first level is your siblings. The second level will be the cousins and the other relatives class to legal heir of father. So some or other out of them will inherit.
थैंक यू।
Can it be willed for an NGO? Yes, you can, Sarika ji. That is what I have discussed during my presentation, that if you want to give away anything to anyone who is not a relative as per the succession law, then will is important. And yes, you can always give to an NGO through your will. Though I would suggest, if you are considering that, it's better to create a trust and support the NGO instead of giving the assets to the NGO. Bharat Malhotra. There is one more question from Bharat. Yeah.
We now close the session. Thank you राजकुमार लाखोटिया जी for today's session. आपने अपना वेल्युएबल समय निकाल के हमें दिया है। आज का टॉपिक पे आपने सक्सेशन प्लानिंग कैसे करना है, क्या नहीं कर सकते, क्या कर सकते हैं, इसके लिए अपने क्या क्या चीज यूज कर सकते हैं, कैसे कर सकते हैं, तो ये हमने जाना। और ये हो सकता है आने वाले दिनों में हमारी लाइफ में, इनफैक्ट ये सभी की लाइफ में जरूरत है। एवरीबॉडी हैज देयर ओन एसेट्स एंड ओन प्लानिंग, किसको क्या देना नहीं देना। अगर ये सक्सेशन विल करके प्लानिंग करके अपने जाते तो पीछे वाले लोगों को परेशानी नहीं होगी। तो थैंक यू राज लोखटी जी, थैंक यू यस बेद जी for today's special address, and thank you participation for listen hearing, patience hearing, and participating. Thanks to all.
Thank you so much. Thank you for the invite. Thank you so much.